is that we can import people to this area, increase the amount of residents, bring younger people here, and really put Wolfville on the map. I've been very happy to work in craft breweries. They use beer as a means to support their communities, create jobs, and import people to the area. I look at beer as an import-export product. You might be able to put it to other communities throughout the province, and that will bring people to your community. I'm not going to take up much of your time tonight. I just want to say a few words and thank you for all your efforts that have gone forward with this bylaw changes. Thank you.
Thank you, Bruce. Thank you, Bruce.
Good evening, Mayor, Council. My name is George Lonis. I live at 581 Main Street in Wolfville. This is obviously a very difficult decision when you have speakers who have come up this evening and described the opportunity they've now had to come back and work in this community. That's obviously something that is very important if Wolfville is going to carry on into the future and to have a stable tax rate, both from the point of residential taxes and also the commercial tax base in the town. However, that I don't rise to speak in opposition to the success or unsuccess of the Church Brewing Company. Like Mr. Daniels, I'm concerned with process. And I think process is important. And ultimately, if we have no process, then we end up with a good degree of unfairness and a lack of equality in the consideration of various development proposals that are brought to the town. I mentioned this briefly at the first council meeting where these amendments were to be considered. And I compared what's happened at 292 Main Street to what's happened with the Church Brewing Company. And it's because of the way the bylaws are written and the bylaws are interpreted. I have been in Wolfville as a citizen for just going on 6 years now, and I've come to believe, unfortunately, that Wolfville, as regards development proposals, it's winners and losers. There doesn't seem to be the attitude of providing for some degree of meeting of minds on development issues within the town. And so you end up with extremes. And as you end up with extremes, you end up with a council that takes one extreme or the other. Having said that, I think what we've seen to date with the development at 292 Main Street is an example of where a developer came to town originally with a, let's say, a highfalutin development proposal. And over a period of 2 years, because, I think primarily because it required a development agreement, that developer has worked with planning staff, and you are presumably shortly going to have this before your council as it was considered a PAC, the latest revision of the plan for that property. In the case of the Church Brewing Company, there's no requirement for a development agreement, apparently, at least as has been interpreted by town staff and the development officer in particular. And as a result, there's absolutely no requirement for any concessions, any coming back on the part of the developer, as was the case with Mr. Gilder's development, proposed development at 292 Main Street. And so you have this inequity that exists within your bylaw and your NPS. Mr. Daniels commented on the staff report that was brought to council in March of 2018 when you gave final reading to the bylaw amendments at that time, and he's absolutely correct. There is no reference in the staff report, no mention apparently, I wasn't at the meeting, I'm assuming there was no mention at the meeting of the fact that the Church Brewing Company was ultimately planning to sell off-site. In a public statement posted on the town's website, you confirmed that was the case, fact, you confirmed that was the case up to and including the issue of the development permit by the development officer, and that she had no knowledge, as I understand, if I'm reading the public statement correctly, that the church brewing company would be seeking to sell off-site. If there's anything that can be said about Judge Warner's decision, is that it is abundantly clear, there is absolutely no doubt in his mind that the land use bylaw of the town did not permit off-site selling in this particular instance, as it did not satisfy the definition of ancillary uses and the exclusive devotion of the ancillary use to the main use. That's clear. There's no misunderstanding in Judge Warner's decision. When you have a situation where the courts have ruled on something and the developer, I'm guessing, that's all I can do is guess, that the town will ultimately change the bylaw and change the MPS, and the building continues and costs go up and up and up and up. So then you have this horrible situation where a developer has spent a lot of money, and it puts the town in the very unenviable position of trying to say no in those circumstances. But that's what you've gotten yourself into. I hope that when you consider the voluminous quantities of material that have been submitted to you for your reading, and the submissions that have been made here tonight, that you'll think about that when you make your decision. This is a very important decision from the town, not from the viewpoint of the success or failure of any particular business. That's not what we're here for. We're here to try to have a process that's fair to all developers. And I hope that in the new MPS, whether it's going to be through this hopefully increased use of site development agreements, site plan agreements, that there will be an opportunity to have greater control and perhaps greater fairness in development in the town, and we don't have situations like we do today where one developer is put through the hoops and another developer really doesn't have to satisfy a whole lot just because of the nature of the bylaw and the interpretation of the bylaw. So I thank you for hearing the submissions that have been made. This has been a very hot and heated topic within the town. And alongside the employment issue, obviously one that's of great concern to anybody in the town, I think, in terms of having employment for people, but that has to be matched alongside the process, and process in this case, I think, has not been what it could have been. So thank you for your time and consideration.
Thank you, George.
Good evening. My name is Stephen Drehos. I live at 311 Main Street. My wife Carrie is not here tonight because she too is fed up with the lack of process that has occurred over the last several months regarding this project. She told me tonight, she says, no matter what I say or do, apparently the council has already made up their mind. The fact that they're going to vote on it the very next day speaks for itself. And I think a lot of us have a problem with the process. It's not the fact that, I'm talking about jobs here, it's the location of this church. You could have the same amount of jobs if this facility was located in the proper place. You'd still have 60 jobs. You'd still have a brewery in town. It would just be in the appropriate place. That's why we have zoning laws. That's why we have a process. That's what Judge Warner said. He said to allow off-site sales would be, and I quote him, make the town, that part of the town, a, quote, industrial park. Those aren't my words. Those are his words, and he has no skin in the game. He's just a judge. And I think a lot of people have a problem with the fact that, and I'm quoting from Mr. Hasem's letter dated February 25th, in which he states, any proposal or amendment to limit the volume of off-state sales would be an error